Boa noite a todas as pessoas que nos prestigiam com a audiência nessa noite. Meu nome é Bryan Longo, eu serei o presidente dessa conferência especial. Eu informo que essa conferência será realizada no idioma inglês, então, a partir de agora, trocaremos de idioma, mas quem quiser fazer comentários em português, enviar perguntas em português, a gente fará a tradução no decorrer da apresentação. So, good evening, everyone. My name is Bryan Longo. I'll be hosting this special conference on taking of evidence in international arbitration. This special conference will be held in English. Before we begin, I'd like to congratulate the staff of this Brazilian Congress of International Law, especially Professor Wagner Menezes, but also the whole team that is making this Congress possible. I would also like to personally honor Professor Claudio Finkelstein, which is by far one of the most generous people I've had the pleasure of meeting in my professional and academic careers. Our lecturer today will be Professor Gerson Damiani. Dr. Gerson is a professor of law and international cooperation. He's the Attaché for International Strategies at the University of São Paulo Dean's Office. He's the creator and the executive director of the Global Institute for Peace Studies and Conflict Resolution Center. Holds degrees, including a PhD and a postdoctoral studies from institutions such as the Hamilton College, New York, Université Paris-Sorbonne, Humboldt University and Freie Universität in Berlin, and also from King's College in London and the University of California in Los Angeles. He's also one of the people responsible for introducing me to international arbitration, and I thank him very much for opening this door for me. So without further ado, Professor Gerson Damiani, you have the floor.
Thank you very much, Bryan. It was indeed a great surprise to see that you would be presiding the session today. And that shows to me, to all of us, how the world turns around in a very positive and pleasant way. Today, we're talking about a topic that I generally take a full semester to teach. So I'll be addressing just, very briefly, two of the most, which I believe to be the most important issues in taking of evidence in international arbitration. And certainly will be open to you for further questions and initiatives if you may wish to contact us at the Global Institute for Peace and Conflict Resolution at the University of São Paulo. First and foremost, after thanking and congratulating Bryan for the brilliant development of his career, I'd like to also thank our Professor Wagner Menezes, a dear friend, and all the organizers of this important event, and making sure that despite of all issues and difficulties we have been dealing with, it's taking place, and so congratulations and kudos to the administration, the staff. One of the questions that I have is that if I share my screen, can you still continue seeing me? Let's do a test here. Let me share my screen here. 1 second. Share screen. Easy to know. Share screen. So, share. Your entire screen, application window, share. It's not really. Is it sharing for you?
No, not yet.
No. Wants to share content, choose what you'd like to share. One of the issues that we have here is that I'm a Mac person, and it seems like this program is not very Mac friendly, but it doesn't matter. Let me try. I think it worked now. So can you continue seeing me, or just the screen?
No, you can proceed. We are seeing you and the presentation.
Okay, so after thanking everyone for this, I would like to also thank Professor Martin Hunter. As some of you may know, he is one of the fathers of international arbitration, and for us who have had the opportunity to partake in some of these MOOCs around the world, including Vienna and Hong Kong, that handle the CISG, for instance. Martin Hunter is the person with whom I teach this course. both at King's College and at the University of Miami. And if I move on to the importance of international, the production of evidence, you know, in international arbitration, I apologize to some of you who are very familiar with this topic. I don't want to bore you, but I'm speaking today more directly towards a general audience who may not know some of this international codes. So when we talk about international arbitration, in my opinion, there are three very important regimes, international regimes, that we should become aware of. The first one is the New York Convention of 1958. The New York Convention is for the enforcement of international arbitral awards for all of the countries who have signed and ratified it. May be noted that Brazil, for a very long time, had some delay in ratifying international agreements, even though the country participated in drafting it, in discussing all of its specifics. And for example, the New York Convention of 1958, which guaranteed the enforcement of international arbitral awards, was not ratified by Brazil until the year 2000, which is almost half a century later. And the CISG, which is the Convention for the International Sales of Goods and Services, signed in Vienna in 1980, it was not ratified by Brazil until 2013. So you can observe that Brazil was there in the early stages, but it took a long time for it to incorporate it into its domestic jurisdiction, into its domestic body of law, let's put it this way. And the third regime, the one that I'm going to address more specifically today, is the regime for the production of documents, international arbitration, which is known as the IBA rules, the International Bar Association rules. So if we move on very briefly, just to give you a spectrum of the CISG, which is the United Nations Convention for the International Sale of Goods and Services. It was born at Ancitral in Vienna, you know, the United Nations Commission for International Trade Law. And if you see, in April 1980, when it was signed, there were 42 signatory states. And currently, it counts with more than 80 states. I mean, if we follow up with this number increases year by year. So now we must be even near 90 states, if not more. Brazil ratified it in 2013, and it became effective. It took 1 year for it to become effective, and it became effective on April 1st, 2014. Why is this body, this regime, so relevant for us who handle with issues of international law? It's important because there were many attempts that came before the CISG, but none of them could encompass a sufficient number of countries with different law traditions. So this regime specifically, it is able to encompass both a body of countries that handle its domestic jurisdiction through civil law, and those who handle it via common law. So you would observe that even during that time, we're talking here, we're in the middle of the Cold War, right? But we had countries such as the United States and Cuba. We had Germany and China. And then, you know, countries that come from different economic backgrounds and also legal backgrounds. So finally, the CISG was able to unify the world into this one body of this convention that allowed for a better exchange, a better way of resolving commercial conflicts around the globe. If we move forward to one of the aspects that I wanted to bring to you today, the IBA rules may be noted that they are more destined as guidelines. These are not mandatory. They're not conventions that countries must abide by, but they function more like guidelines for good practice of international arbitration. So in 1947, associations and bars around the globe came together and created the International Bar Association. And so far, there are 4 very relevant guidelines that those who deal with international arbitration observe very closely. So here we have the guidelines on conflicts of interest in international arbitration, which has a new version from 2014. We have the guidelines on party representation in international arbitration from 2013. The rules on taking of evidence in international arbitration, which is what we'll take a glimpse on today, and the guidelines for drafting international arbitration clauses. So those of you who want to deal with international arbitration, I very much recommend that you take a look at these guidelines, because they will be a very important tool for you throughout your professional careers. So these guidelines, some of them function with a metaphor of a traffic light. What does that mean? You know, the metaphor of a traffic light is actually not only a metaphor, it's also directly stated at the guidelines, the IBA guidelines, which means that if you are in doubt, let's see, the appointment of arbitrators. So if an arbitrator has been appointed more than twice for the same party, then you would go from a green light into a yellow light, and from a yellow light into a red light. So this should really give you a measure of whether you are abiding by good practice in international arbitration or not. Today, I would like to introduce to you 2 different nuances of the IBA rules on taking of evidence in international arbitration. And for some of you who deal with the United States, who have clients or study US law, you understand the meaning of discovery. Discovery is a request to produce documents. I'm not talking about arbitration right now. I'm talking about litigation per se. So one of the strategies that many legal offices and lawyers in the United States have, which differ, it's different in the UK and in other common law countries. This is very specific to the United States. They plunge you with documents. So documents that are not even necessary. It's a strategy to delay the process. So this discovery process is called by Martin Hunter, whom I mentioned previously, as disco very, you know. So he makes an anecdote out of this to imply that this could never be introduced into international arbitration, because the idea behind international arbitration is to expedite the process and not prolong it, as we may imagine that this process of disco very would do. So those who drafted the IBA rules on taking of evidence in international arbitration, the model that I'm showing to you here right now is that of May 2010. I would like to bring to you 2 concepts, and if those 2 concepts remain with you today, I'll be happy. I think they will suffice for you to move forward into understanding the taking of evidence into international arbitration. So I would like first I mean, when you go through this to these rules, the IBA rules, I suggest that you carefully read the definitions. You know, they have definitions, what they mean by document, evidentiary hearing, expert report, and so forth. I'm not going to go into detail on this right now because obviously we don't have the time. Let me try to make this screen a little bit bigger so that I pinpoint to you a point that I find very important. If you go to Article 3 of this IBA rules on taking of evidence in international arbitration, and from Article 3.3b. So notice how this is very subtle. It says, a request to produce shall contain a statement on how the documents requested are relevant to the case and material to its outcome. It's not saying or material to its outcome, because a smart litigator may say, no, everything is relevant to the case, correct? But it has to be relevant to the case and material to its outcome. Do you understand the difference? If we had here the word or, it would make a difference. So if as a strategy in an international arbitration, someone is trying to litigate it to its utmost possibility, the arbitrators can refer to this and say, okay, the documents are relevant to the case, but are they material to the outcome? Are they going to make a difference in how we make a decision on the outcome of this case? You know, how the award is going to be written. So if they're not both relevant and material, the arbitrators in this arbitral tribunal may decide to put it aside, okay? So this is a very important concept that I would like for you to retain. So if you go to Article 3.3b, relevant and material. Another point that is very relevant here, and I may need to change the document that I'm sharing. Let me try to share a different document here right now, which application window. Here we go. Now I'm going to Article 9, and I'm talking here. No, it didn't work. I'm sorry. Article 9. Shit. Are you being able to see this, Bryan?
I'm seeing there's a 6 and 7 screen.
Okay, so let me
highlighted
make it a little
for
larger, if I may. Let me try this here. Stop screen, and then I'll try to share it again. Share screen, application window. Let me share this. Does it work now?
Yes, I'm seeing there's a highlighting may infer the such evidence.
Okay, so this is not, this here is what I want to show to you. Do you see may infer? Is everyone being able to see that? Okay, so now we're talking about article number 9.6. So here we go. A party is not obliged to make available documents, evidence, relevant evidence, including testimony, or sought by one party, you know, or the other party that has requested it. But if the party decides not to provide such evidence, this allows the tribunal may infer that such evidence would be adverse to the interests of that party. What does that mean? This is a concept called adverse inference in international arbitration, specifically in the topic of production of documents. So what we're thinking, the background of this here is to avoid that in the future, the party may wish to annul that arbitral award. So if we're thinking about good practice in international arbitration, and those who practice international arbitration and abide by the IBA rules, would understand that a party that refuses to produce documents, that party may be hiding something, may be hiding important information, may be hiding relevant testimony. So the Article 9.6 of the IBA rules on taking of evidence in international arbitration allows specifically that the tribunal may infer that such evidence would be adverse to the interests of that party that's hiding such information. So if you grasp those two concepts, which is the concept of materiality, relevance and materiality, and the concept of adverse inference, I think that we are moving in good steps towards what we call good practice in international arbitration. And with that, I think I've been speaking for almost 25 minutes now. With that, I would like to see if Bryan has a question, would like to make a comment, or if anyone else would like to contribute.
Well, if anyone would like to present a question, we're open. So to start out, I think that the huge problem that a tribunal faces when being presented with a request for the production of documents, it's how much judgment can be made at that step, because deciding whether a document is relevant may be understood as a decision on the outcome of the case itself. So as an indication that if the document produced says what you say it will say, then the case will be decided in this way or the other. So if you could provide a tip or a tiny commentary on how a tribunal might face this. For instance, it has to decide whether the document that is being described will be relevant to the outcome, but how much this decision might go in deep of this materiality, because at what time it crosses the line and becomes a decision on the merits of the case itself.
That's a very good point that you are bringing here now, Bryan, because I mean, you're talking about relevance and relevance and materiality. So let's put it this way: we are discussing party A is a party that produces. It's a shipping company, okay, and this shipping company has been brought up to this arbitral tribunal because of the delay of a shipment of copper from Chile to Germany. So there is a delay on this shipment, the specific shipment of copper that arrived a month later in Germany than expected, and that created some costs, some damages for the party that was receiving it. So an arbitral, a group of a council that is wishing to produce documents for the reason of this delay, if they produce the documents that are relevant, that are specific to the shipment of copper, that's relevant and material to the outcome of the case. But if this company buries you with documents from the past 10 years of copper and grains and all sorts of other exports that they have done, they may say it's relevant, but it's certainly not material to the outcome. So this would be an example where the materiality of this rule is very relevant.
Thank you very much. I see that we still do not have any questions from the audience, so a final question for us to conclude. When you're dealing with adverse inferences, and you touched upon the New York Convention for the recognition and enforcement of arbitral awards, how is there an international standard of adverse inference? Is there a standard that all nations accept some sort of adverse inference, or is there a problem when you, as a tribunal, relies on adverse inference and then your your arbitral award will be enforced in a country where adverse inference is maybe not as much common or as regular as this. So does a tribunal has to have this in mind? Well, not only the adverse inference here at this arbitration itself, but also how will this adverse inference affect the effectiveness of the arbitral award that I'll be handling?
Thank you, Brian. You know, as legal scholars that we are, you know that there's no common agreement on anything in law, right? There is the power of being able to bring a good argument. But if you mention the word standard, the IBA rules on taking of evidence in international arbitration is certainly the highest standard there is on a topic such as that you have mentioned. So adverse inference is it's a very important to acting in good faith. The party that is requesting a document and the other party is refusing to produce it, it raises the issue of, is there a reason why the other party is not willing to produce this document? I'll say that in practice, international arbitrations take it very lightly. But if one arbitrator or an arbitral tribunal decides to take adverse inference due to the fact that the production of documents was denied by one party, in good practice, in good international arbitration practice, this adverse inference will be accepted as a common standard for the arbitral award not to be annulled. So I will finish here by sharing my my contact with those who may wish to contact us. We have created an institute at the University of São Paulo called GLIP, and GLIP is the Global Institute for Peace and Conflict Resolution at the University of São Paulo, and we are now uniting efforts to produce scientific and academic work related to conflict resolution, not only arbitration, international arbitration, but also mediation and dispute boards. And we will be very happy for all of you who wish to contact us to join us at GLIP, which is glip.usp.br.
Thank you very much, Professor Gerson. It was great to see you again,
yes.
Although remotely because of the pandemic, but I'm very glad to be with you here tonight. I would also like to thank again Professor Wagner and to honor again Professor Claudio Finkelstein. And with this, we conclude this special conference. And I'd like everyone to stay in this Brazilian conference. We will now have another special conference. So I wish you all a great evening and a very productive Congress, not only today, but until Saturday. So good evening, everyone, and thank you, Professor Gerson, again.
Thank you very much, Brian, and thank you all the organizers for this.